When you're prepping the question, you should first present the argument that you're going to run, so present it from your point of view. Then you should try and re-prep the question and approach it from your opponent's point of view, so you can identify their chief objections and their chief arguments. You should then re-prep the question from your point of view, taking into account the arguments you anticipate they'll be running and their chief objections, so you can develop counter-arguments to them and ways to bring the evidence out which don't allow them to make those objections.
I think the first thing students should do when they get the question is to read it through thoroughly, as well as the section that they're looking under. Have a read of the section and identify which elements you have, which of those are going to be contentious, and think about where you want to, which of those elements you want to address. Have a read through firstly the statement for your side and then the statement for the other side, and have a think about how the whole thing fits together, and try and put it in a realistic situation. How would this question actually operate in the real world, so that you understand what case you're going to be aiming to make, and then be trying to tie that back into the section. But yeah, certainly just having a read through it carefully, taking some notes, highlight some things, and have a think about the overall picture.
Okay, so the first thing that you do when you get your question is obviously read it. And read it twice, 3 times, as many times as you need to read it to understand the question. I freak out a little bit when I read it, and then just calm myself and look at exactly what I need to do for my case. This applies whether you're prosecution or defence, so it doesn't really matter. I always write my conclusion first, because you don't know where your case is going unless you know where it's going to end. So I always write my conclusion first, get my case theory out there, get the elements of the law out there, look at the act really carefully, make sure you satisfy the elements in that legislation. Then I go back and do my cross-examination. Cross-examination is always good to do second, because you can pick out the flaws in the other side's case. So you could have your case done, but you need the other side's case as well. Then I do my examination in chief. Just gently, slowly, and then do my introduction, and I spend about an equal time as I did on my conclusion. But the most important thing that I do as soon as that's all done is make my witness feel comfortable, make sure that my witness knows the case as well.
If I could take appearances, please.
Your Honour, my name is Mason. I appear for the prosecution.
Thank you, Mr. Mason.
And Lee appearing for the defendant.
Thank you, Mr. Lee.
Cross-examination is probably one of the hardest skills to learn. What you're really aiming to do is to firstly be undermining the other side, but also building up to the best you possibly can your own side's case. I think the most important thing that participants should be doing in cross-examination is asking questions. Asking lead-up questions. So you think about a point which you want to get to, what you want the witness to say, and think about what questions do I need to ask in the lead-up so that that person will eventually answer that question in the way that I want them to do it. So again, thinking, and think about the areas that you need to be asking questions on, always linking that back to your case and the elements, of course.
You should always be calm, collected. Don't let your tone of voice change unless you want to tip the witness off. One of the more advanced tips is to try and push the witness down a set of stairs. Each stair is a positive or negative answer, but they say the same. So it'll be a series of yeses or a series of no. Then you get to a question which the witness has to answer the opposite to their previous answers, but because of your tone of voice, your manner, your demeanour, and their previous sequence of similar answers, they have a tendency to answer that question the same as their previous answers. So phrased correctly, you can destroy a witness's entire credibility with that one answer, because they don't anticipate it's coming and they fall into the habit of answering a certain way.
And what were you doing on the night of the 7th of March?
Well, I got home from work and then I had a shower and I put on my best hat.
Cross-examination is where you're going to lose your points or where you're going to make your points. I've seen great cross-examinations and I've seen bad cross-examinations. Good cross-examinations, you have to know the other side's case inside out. You could know your case really well and get 20 out of 20 for your examination in chief, but you don't know their case well at all, and you get 13 out of 25 for your cross-examination. So look for small things in their case that you can use to make your case better. When someone was running away from the scene, did they wear shoes? Did they not wear shoes? Why did they lose their shoe? Always look for the main things in their case, or the main things that the prosecution or defence has relied on in their case, and attack those points in your cross-examination, because that's where the judges, that's where their case theory lies.
And I put on my best hat, and then I went down the road to the bar.
And you went to the bar with your best friend Luke, isn't that right?
Objection!
On what grounds?
That question was leading.
It's not in contention, Your Honour.
Upheld.
Through juniors, I learned, the main things of, court etiquette, and addressing things as Your Honour, and, sitting down when the other side's speaking. But through seniors, the most important thing that I've learned is learn your Evidence Act. Because if you know your Evidence Act, you're unbreakable when someone tries to argue your point, where you've got evidence law that backs that up. Brown and Dunn, the Brown and Dunn rule. I'm still learning the Brown and Dunn rule, but getting there, and I think that's an advanced technique that I've seen a lot of the senior WITXs do. And also, I guess, just generally, is having a really good conclusion, because if you're able to succinctly state every single one of your points and succinctly state word for word what the other side has said and why you disagree, you'll blow that judge out of the water.
In terms of advanced techniques, I think one of the key things is actually using your preparation time most effectively. I think you should be using this time to build up your case as much as possible, making notes constantly about what you think are going to be the key issues, things you need to remember, things you need to instruct your witness on. And also the time when you actually get to speak to your witness, make sure you bring them into the case, make sure they feel comfortable, discuss with them the kind of direction and the case theory that you're hoping to address. Because I think that 90 minutes beforehand you can actually get a lot of work done, and particularly if you've got a witness who's on side with you, then they become an ally and you have a better chance of success.
Always take notes of your opponent and take notes of your judge's feedback. You should never lose a WITX the same way twice, and you should never have a judge make the same comments about you twice. Every opponent will do something better than you do, and you should take care to learn from that and try and incorporate that into your WITX and your WITXing style.